Morning, everyone. Thank you for joining us on this morning's webinar, Property Q&A Guidance for the June Quarter, presented by Myers and John Flathers of Leeds. We're also delighted to be joined by Will Moroney from HBD. Before I pass you over, can I just ask if you've got any technical issues during the webinar, that you put these in the chat function, and any questions for the presenters, use the Q&A function. Thanks very much, and I'll pass you over to Phil.
Good morning, everyone. So, thank you for that introduction, Tom. We're in very strange times, as you all know. The world, and in particular, the property world, has really been turned upside down. What we're going to try and do today is to explain what remedies are available and try and answer as many questions as we can that you may have. So, as Tom says, feel free to put questions through at any time through the Q&A chat button. Now, what I will start by saying is that some of you have been on similar free seminars where talked about the remedies that landlords have. I'm going to go through those briefly now, but also I'm going to look at really what the positives, what can be done by landlords, what can the tenants do, and thereafter, later on, we're going to look at what the future holds as well. So the landlord still has all of the usual remedies, albeit they are, of course, somewhat curtailed by legislation which has come through, like the Coronavirus Act 2020, that affects all sorts of things, of course, including commercial property, and also the Commercial Insolvency and Governance Bill, which is yet to come through, but is very relevant, as I will come to shortly. So just quickly going through the remedies that remain available to landlords and the effect of the COVID restrictions. So court proceedings, of course, landlord can, if he's owed money under the lease, can issue court proceedings to recover rent or indeed any sums, any outgoings due under the lease. It may well be that the tenant has no defence to the claim, and therefore the landlord can issue the claim, including interest and the legal costs if he's instructing a lawyer, and the court costs as well, of course. There you go, it issues it, may get judgment in default if the tenant doesn't acknowledge service or submit a defence. But indeed, the process can be protracted and can be expensive. To a great extent, the tenant might use it to drag out the process to buy more time. Yes, you can think about applying for a summary judgment if you're the tenant, if you're the landlord and wanted to get judgment quicker against the tenant, but there's no guarantee, and summary judgment applications are notoriously difficult and uncertain. And just because you've got a judgment, of course, that doesn't guarantee any payment forthcoming. It's ultimately just a piece of paper. But there's no restrictions on pursuing this process through legislation under COVID. Statutory demands and insolvency proceedings. Again, yes, you're owed money. As long as it's more than £750 for commercial tenants, then you might think about issuing statutory demands and with a view to presenting a winding up petition. But there's a few points on that. First of all, as you may know, the courts don't really like the insolvency process being used as a means to debt collect. And also, it's a group action, so you're forcing an otherwise solvent, potentially solvent individual or company into insolvency, and all the creditors come forward, and you may end up with nothing or X pence in the pound. But watch this space. As I mentioned, the Corporate Insolvency and Governance Bill is shortly due to have its third reading next week, I believe, in the House of Lords. And the effect of that will prevent winding up petitions being presented on or after the 27th of April, where they rely on a statutory demand served during the 1st of March to the 30th of June 2020, or longer, being 1 month after the bill actually comes into force, which looks like it will be into July. But that's only where the inability to pay is due to the effect of COVID-19. Having said that, of course, it's a very difficult hurdle to overcome if you're the landlord, and very easy to say it's COVID related if you're the tenant. But I'll come on to that again shortly. Very briefly, because they're not particularly popular in any event, are commercial arrears, commercial rent arrears recovery, CRA, still often referred to as distress for rent or distraint of goods. But essentially, this is where if a landlord's owed money, then they pursue a process whereby a High Court enforcement officer makes an appointment to attend a tenant's premises to seize goods, often taking a walking possession order. In the first instance, it's like, here comes the bailiffs, and ultimately can seize the goods. But there's issues with that. First of all, in any event, the tenant will get notice if there's anything of value on the premises. They may well not be there by the time the enforcement officer comes. And secondly, the amount of arrears that have to be outstanding now as a result of the Coronavirus Act is extended to 90 days rent. There's also issues potentially in terms of the enforcement officers willing to attend, although that's less so now because people are leaving their properties more, as you know. Forfeiture. Okay, so everyone knows what forfeiture is. Essentially, a landlord's right to end the lease, peaceable re-entry or court proceedings. Now, it's probably not going to be in the landlord's commercial interest to take the property back at the moment. There's also the issue of relief from forfeiture that the tenant or any subtenants may be able to apply for. And also, of course, the landlord will get the premises back. So although there may be a short, perhaps 3 months hiatus for payment of business rates, ultimately the premises fall back to the landlord. It has a void and it's got the liability. But of course, the Coronavirus Act has now suspended the landlord's ability to forfeit until at least the 30th of June. And we think may be extended beyond that. However, anything that the landlord does do during this period will not waive the right to forfeit. And waiver, as you may know, is where the landlord does something or says something to the tenant which treats the relationship between the landlord and tenant as ongoing, such as demanding rent, sending out rent invoices. Anything that happens now will not waive that right, but it's still advisable not to do so. Rent deposits. A landlord might have a rent deposit. There's nothing that prevents the landlord from drawing down on that. It's a quick and simple method often of recovering rent. It may well preserve or help preserve the landlord's and tenant relationship during this time. There's no impact on the tenant's cash reserves either. You have to follow any process in the deed, but of course what happens, the landlord uses the rent deposit monies. He may have already done so, of course, for the March quarter. There's nothing left in the pot and the tenant may refuse or be simply unable to top it back up. And finally, tenants may have guarantors, sureties under the lease. That's a good option for the landlord to look at. The guarantors may have no defence to refuse to abide by their obligations. However, the guarantors may no longer be solvent. And you're also potentially subject to the same restrictions in terms of statutory demands and winding up petitions. And of course, there may be authorised guarantee agreements. What are they? Well, they're the ability to pursue previous former tenants or guarantors under the lease. And there's a process that the landlords need to go through by serving notices within 6 months of those sums becoming due. All that can be done, but again, it's not clear at this stage whether statutory demand or winding up petition restrictions may also apply to guarantors. So to summarise this point, forfeiture for non-payment rent currently prohibited till at least the 30th of June, but not forfeiture for other reasons. There may be other reasons why you can forfeit the lease. You'll have to serve, as a landlord, a section 146 notice on the tenant, giving them a reasonable opportunity to put that right. So as I say, forfeiture you can't do for rent and other outgoings, but there may be other reasons why you can at least take steps to pursue the forfeiture process. Statutory demands pretty much, yeah, they're on hold now until at least 30th of June, and similarly with the presentation of winding up petitions and commercial rent arrears recovery. Yes, you can still trigger that, but there's got to be 90 days rent accrued, and in any event, nowadays they're not the best method unless you know that there's going to be sufficient assets at the premises. So where does that leave us? Is there going to be mayhem in July? Well, we'll talk about that in more detail with John shortly, but probably not. I think we're okay. I think we'll be okay. The 3-month extension to the moratorium is rumoured to be extended to the end of September or even October, and I think it's important to mention there's been a recent case. Of course, the corporate corporate insolvency and governance bill 2020 isn't yet enforced. As I say, the third reading is due on the 23rd of this month. But in a case called snappily called, I think the courts often choose the best titles, I would say, in a company bracket injunction to restrain the presentation of a petition 2020. The judge, Justice Morgan here, made an order restraining the presentation of a winding up petition, not on the basis that not on the basis of the existing law, but on the basis fundamentally that this bill, the Corporate Insolvency and Governance Bill, is likely to become the law in the near future. So that sparked quite a lot of interest, and that really goes to show that it's going to be pretty easy for tenants where statutory demands are served on them to cite this case and to injunct, in other words, to restrain the presentation of a petition. So insolvency is pretty much no go at the moment, but there is hope, and there's things that certainly that can be done, and I would suggest should be done, and certainly should be looked at. So personal guarantors. Remember, the legislation applies to corporates, not individuals. There may be directors who have given personal guarantees to standard sureties. Now, there may be issues in terms of going after them. What assets do they have? But the threat of proceedings against individuals may be sufficient to procure payment. Authorised guarantee agreements. Excellent. Serve the notices under Section 17 of the Landlord and Tenant Covenants Act 1995. Guarantees generally, sureties. If the surety is trading well, it may well pay the rent when you look to it under the terms of the lease. And rent deposits, if they're there, have a look at them. At least if there's funds there, yes, they may need topping up, but certainly why not draw down now, following the correct procedure under any deed. And what I would also say is, as I mentioned at the beginning about corporate proceedings, but if you secure a judgment in the court, the county court or the high court, that stays good. There's no absolute limitation period on pursuing that. 6 years is really the date by which a court judgment ought to then be enforced. You can enforce it thereafter, but there may be limitations on interest, for example. But 6 years is a long time. We'll be well over this. So think about securing your judgment. Remember, CCJ also may have an impact on the tenant anyway. People don't want CCJs against themselves, against companies. So again, that might prompt them to make payments. It's all about relationships, though. We'll talk about that. You want to try and maintain a good relationship, but if your tenant's not talking, if there's no if there's nothing coming from them, if there's no give or take, then think about these. I'm now going to pass over to my colleague John, who's going to talk some more about.
Phil, just before you go, can I ask you just a couple of questions, which I have sort of been. I mean, first of all, I've heard the date's been postponed to 23rd of August, but I think that's in relation to individual tenancies rather than commercial tenancies.
Yeah, that's right. So possession proceedings for residential properties are currently, as John says, suspended, but that's now been extended to the 23rd of August. And, that makes it, we think, possibly more likely that commercial possession proceedings will similarly be extended, whether that's to the end of August or September or October, we don't know. And I think that it'll be very telling in the next couple of weeks as to what happens. We're about to hit the 30th of June. And remember, these moratoria are up to effectively the 30th of June on the commercial side of things.
Thanks. The other question I just wanted to raise was, not being a litigator, I'm sure the audience is going to be interested. Whenever you get a judgment, you're always ending up with a stat demand to enforce it or a winding up petition, all of which are dead ends to landlords. So can you pursue a court process through without having to end up using a stat demand, get a judgment? How do you enforce that judgment? How long does it take? Could you just possibly help me and possibly some members of the audience as well? Can we go down that route? Because that seems to be the only avenue at the moment that's left if you're going to follow that type of process. Absolutely.
Well, there are different ways of enforcing a judgment, and strictly the insolvency process isn't a method of enforcement. Of course, it's an entirely separate process which brings in all the all creditors together, and you may rank pretty low. The taxman might take everything, and you'll be left with nothing. So what we usually do once judgment's obtained is look at what assets the defendant, the debtor, has. Property is always a good one in terms of applying for charging orders. But remember, as I said, there's nothing to stop applying for charging orders, so it's effectively a charge over the property. We can still do that. Some courts are a bit slower than they were because of the pandemic. But look at charging orders against properties. Something we're also doing is, particularly for individual debtors rather than corporates, is getting them to attend court, applying for an order that they attend court to answer questions about what resources they have. They don't want to do that. Again, that's a potential route to payment. Third-party debt orders. If you have, for example, details of accounts that they have, bank accounts, you may, in certain circumstances, be able to get an order that money's paid from their bank to you. So there's other ways to enforce a judgment, and we would obviously look at the particular circumstances of the debtor and try to identify how that might best be pursued. But ultimately, having that judgment, there's no rush. Yeah, I appreciate that our clients will want the money now, but if they can wait a little bit, it will open up all the options, and perhaps in a few months, in a year's time, and we can then pursue the judgment then.
And I think also you've touched on before with me that the fact the court process can be slow. There's some courts which are very slow. You can apply to other courts, rather like when we used to get the contracting out notices, you'd go to Westminster County Court, which would grant you the order quickly, as opposed to going to, I don't know, Leeds County Court.
Absolutely. So there's all sorts of, I said tricks, but things we can do to speed up the process. So ideally, there's a connection with the court that you're looking to issue at, but it's not necessarily the case. So the Central London County Court is notoriously slow, and things get lost there. If the defendant or our client, the person that's owed the money, are based in a particular location, we'll look at what county courts, if it's a county court, might best serve them, and whether that's a court that might be quicker at processing the applications. Leeds is quite quick. I've known a solicitor in my office who the case had a tenuous link to a court in Wales. They issued there. It was turned around very, very quickly. You've got to be aware, though, sometimes using a court that has no relation to the parties might seek to transfer the proceedings, and that can really slow things down, and that's not good if you're acting for the party that's owed money. If I'm acting for the, not necessarily the tenant, but in this case might be the tenant, proceedings being issued against it, one of the things we can look at is whether we can tactically look to slow the procedure down by saying, straight away, it shouldn't have been issued at this court, it's got no connection, we want it transferred perhaps to the court that's more local to the tenant, and if that's a court where we know things are going slow, that sort of tactic on the other side of things. So there's all sorts of things you can do. Of course, if it's a high court claim, it's over a certain amount, generally claims over £50,000. The high court, a high court is still, in my experience now, working efficiently. It tends to be more efficient anyway.
Great, lovely. All right, great. Thank you very much. Well, that was a very interesting summary. I still think the landlord position is vastly curtailed, and I'm still trying to work out how to get through that myriad of things. But we're going to put a little bit of real life onto it now. So my name for the audience is John Flathers. I'm a non-contentious property lawyer. Phil is obviously the contentious man. So I'm just going to try and put a little bit of real life to it. And we're delighted to be joined by Will Moroney of HBD. And I'm going to just ask him a few questions. I hope he's going to be able to answer the ones I've got. I'll throw a few googlies in possibly, and we'll see how we get on. So, but just before we do that, we are going to have a very quick vote. We're going to do various polls, I should say, on screen. We've got 4 coming up, the first one of which will be now. So if we could put something up on screen, and if you could take 30 seconds just to answer the question, and then I'll carry on after that. Okay. A nice easy question to start with. We'll see what the result is later. Good morning, Will. Thank you very much for joining us today and taking a bit of time out of your day. I just wonder whether we could kick off by you just telling us a little bit about the makeup of your portfolio, how you see the payment profile, particularly for this June, as compared with where we were in March, which obviously was a much better period, I think, because people had cash from the period before.
Yeah, absolutely. Morning, everyone. Thanks, John. Happy to give an insight into sort of what we've seen so far. I think it is worth pointing out at the moment, compared to 12 months ago, our portfolio is circa about 50% less than what it was. And that was definitely down to more good timing as opposed to knowing what we were going to face as we have done so far this year. In terms of our portfolio itself, we've got a real mixed bag. We've got some retail in there, we've got F&B, we've got some industrial, we've got office. And looking at the collection rates for March, we were up about 75% all in. I mean, that certainly wasn't collected by the due date. That's across the whole quarter, what we've seen so far. And in terms of what we're looking at for the next quarter, we are slightly down on that. At the moment, we're forecasting probably about 60%. I mean, nobody really knows what will happen, but I think the positive is that we've got the smaller portfolio, so we are able to adapt and treat each case on a case-by-case basis. We've had to make judgments based on how we think operators are being impacted by the restrictions. But one thing that does stand out is that we're all in this together, and the communication between us as landlord and our tenants has been really good. And generally, yes, June is probably going to be a bit tougher. But we're probably slightly more optimistic than where we were sort of 3 or 4 weeks ago.
That's good. I know when you mentioned 60%, I've heard that across from a number of landlords that that's sort of their target. And as I say, 75% last quarter and slightly higher. So it's interesting how it's coming down, but not a surprise. I just wanted to know also what type of requests you're seeing from your tenants. I'd be interested to know whether it differs from sector to sector. Requests, I mean, in terms of rent reductions, rent waivers, rent concessions, that sort of stuff.
Yeah, I mean, our approach was, I think, sort of back in March, the lockdown happened sort of that week of when the rents became due, and nobody really knew how long we would be in this situation. So our approach across the board was just to defer. Tenants seemed to be happy with that approach. And to be fair, we've had very little requests for total write-off. There's been a good buy-in from tenants that appreciate that landlords, we have also got our own financial commitments to fulfil. It does sound as though tenants are seeing a mixed response from different landlords. Some are facing ultra-aggressive approaches, and some have had landlords that have voluntarily written off some of the rent without even being asked. But yeah, the majority of what we have done so far been deferrals, which we've documented by way of side letters. Some tenants have asked to pay monthly, which we didn't have an issue with. We know that some tenants have been had to close and they've remained so, and others are just starting to sort of get slowly back into the swing of it. Turnover rents have also been discussed. We've had a couple of those that are looking sort of for the next 12 months, which seems a fair way of getting through this together. As a landlord, we certainly rather have somebody in there attempting to trade than coming back, sort of going back to sort of what Phil was saying about the void costs that landlords would be facing. And obviously, as a percentage, if the tenant's performing better than a turnover rent, the landlord gets a better return. But I think where we're seeing a lot of uncertainty at the moment is certainly on the retail and the F&B sector, particularly in respect of the 2 metre social distancing requirements. Just to put a bit of an example, a couple of the tenants that we've spoken to at 2 metres, which it currently stands, they're looking at sort of 60 to 75% reduction on capacity. If that was reduced even just to 1.5 metres, it might be sort of 50%. But if it was sort of reduced to 1 metre, which seems to be the suggestion of where the government might end up going to, it's a 30% reduction. So whilst not ideal, it's certainly a lot better than the current status quo. A couple of our tenants haven't particularly been affected much at all, and it's been business as usual. And also, I think on our mind is how quickly are people going to be going out and spending money. I think there's been an initial, people have been locked down and they're quite happy to get out onto the high street this week. Is that going to continue sort of over the next sort of 6, 9, 12 months?
Great. I'm not going to dwell on it, but in terms of turnover rents, have you seen the base rent go down in percentage amount? I mean, I think it's usually about 80-20 on an ordinary basis. There's talk of it dropping down to 60% possibly, or even lower than that.
Yeah, the requests we've had, they've just wanted to move pure turnover for the next sort of 6 months. So forget the base rent, pure turnover, and then it'll be the maximum, the higher return of turnover or half base rent in sort of 6 months' time, with a view to getting back to full base rent in 12 months.
That's a very fair way of dealing with it. But as you say, I think many landlords still haven't quite got there with that concept yet, have they? That's very fair. Has HBD adopted any particular approach during this? I know that the business as a whole describes itself as very collaborative and relationship driven, which it certainly is. But sometimes you've got to have that little bit of steel in there as well to make sure you get your cash. I don't know whether you have adopted any approach. Any thoughts on that?
We haven't at the moment. We haven't felt as though we particularly needed to. But you know us, you've worked with us for long enough. We don't particularly like making you lawyers richer in legal battles, where we can avoid that. But we have to be aware that the nice approach doesn't always work. In fairness, as I sort of mentioned, we haven't seen many examples of aggressive tenant approaches. Some have helpfully pointed out that our rights to remedy are slightly down on what they've previously been. But across our portfolio, we've only had one example where one tenant has just refused to engage, and they've made it clear that they know there's not an awful lot we can do at the moment. And again, sort of going back to that vacant property issue as a landlord, that it's sort of, we get the standard 3 months rates relief, but there's also insurance costs, insurance measures that insurers want to see us put in place. It could potentially be non-service charge voids, and so yes, so where we can, we want to work with our tenants and sort of keep them in there as long as possible.
Yeah. Okay, just following up on that, obviously slightly disappointed about your comment about using lawyers, but the legal remedies highlighted by Phil, albeit limited, are they important to you? I mean, obviously when the restrictions are released, you know, it could be a panacea, but do those remedies, are they important in your background, or is it more about sort of relationships and dealing with it alone without lawyers?
Yeah, well, first and foremost, it is about relationships, and we have seen a good buy-in, but absolutely, we have to be aware of what remedies are available. We can only make so much judgment on what we think or how we think a tenant has been impacted. We don't like to go down threatening legal proceedings where we can, until at least we've understood what the tenant's problems and the nature of its business, what support they might be getting from elsewhere. we'd expect that where it is available, tenants are taking advantage of government aid measures that they've put in place. But tenants will know that the limits and restrictions that are currently in place won't be there forever, and they need to appreciate, and we have found that landlords also have responsibilities, that commitments we need to fulfil.
Understood. Two more. Just does a tenant's payment history come into your reckoning when you look at what they're proposing and what they're saying? And also, just a quick one, have you got any thoughts on this proposed fairness code which the retail organisations are supposedly drafting at the moment to ensure that there's going to be a fair balance between tenants being honest about what they can pay and also landlords being more sensible about what they will accept?
Yes, I mean, again, with us having that smaller portfolio, we certainly can get a really close feel for our tenants. So if we've got a tenant that suddenly stops paying rent, we're able to sort of jump on that, act quickly on that to understand what the measures we need to put in place. Conscious that that's not a generalisation every landlord will be able to do. Having a smaller portfolio does allow us to do that. But tenants can only be helped if they want to be helped. And I think the most positive aspect of the current predicament is that the communication has been really good and it's been two-way, and we just hope that that continues. Yeah. The fairness code, it sounds like a sensible approach, and it will obviously be there, I think, more than to protect the retail side or the tenants, but hopefully there will be some measures in there that will also protect us.
Okay, final question for you. Bringing the lawyer part back into it, are you seeing many COVID type clauses being proposed in terms of new leases or methods of suspending rent payments should this situation occur again? And as I say, we touched on it earlier, but I think there's going to be more turnover rent type situation, and are you seeing any of that?
Yeah, in terms of the COVID type clauses, it's probably early days for us in terms of what we've actually got going through at the moment. So we've not particularly seen that, but I think it's certainly become the norm in sort of development agreements and construction contracts moving forward. And if it does become the norm, then we just have to adapt. If it was going to be a deal breaker, then absolutely we sort of need to weigh up the benefits of that deal going and being faced with an empty property. We have dealt with turnover rents in the past. We've got a particular scheme that sort of the last 10 years or so, but we haven't seen it on a widespread basis. I think in the short term, yes, it could be a good option to sort of help the tenants as ultimately they want to get through this situation. But then as a landlord, if the retail market in the high street isn't particularly strong, so the turnover rents within a particular store aren't that great, should a landlord be entitled to sort of ask about revenue from online sales? I think there'll be one party that would be keen for that and the other one probably not so.
Absolutely, yeah. Lovely, that's really excellent. Thank you. That's all I've got for you today. Thanks very much. Well, really enlightening. I just wanted to make a few comments about what we're seeing as well on the legal side. And certainly the big question is, will there be mayhem in July? Well, clearly if the time period is extended, which we are hearing that the government are likely to do it, and my prediction is they're going to link it up to the end of the furlough period, then there won't be any mayhem at the end of July. It will have to be mayhem at the end of October, by which time hopefully businesses will have picked up. But I can't see there being any mayhem. I think landlords are sensible and they're only too aware of the need to keep their tenants, as Will has explained. And I think tenants also just want to ensure that their business survives. It doesn't help where landlords when some tenants adopt an intransigent approach. You know, today I think it's a Travelodge CVA vote, if memory serves me correctly, and I've heard rumours that Mr. Ashley of the Fraser Group, as it's now called, has been very difficult with some of his landlords. So that's not helpful. We are seeing a constructive approach from some landlords who realise what the impending disaster could be. And I've heard reports of some really good questionnaires that are being put out by landlords now to try and really get some honesty and work out what the tenants are doing. And one questionnaire particularly, the sort of things that's been in it is stuff like, you know, what is your cash flow going forward? Throw away the old 2019 accounts, that's irrelevant now. I mean, it's probably an indication of what life could be like. So what's your cash flow going forward? How has the tenant furloughed their staff? Have they had to furlough them all, or have they been able to keep quite a few staff during this period? How much cash is in the bank? how the cost of the property will affect the tenant's predictions going forward. They need to understand that. What expenses are they going out? When is the deadline point when the tenant themselves feels they could go into insolvency? When does the tenant expect to move back into profit? If they move back into profit, what's that profit line likely to be? So that's the sort of questionnaire that I think probably this retail group is going to be picking up. However, tenants equally, we've got to face facts. They're mounting, I think, facing mounting liabilities, particularly after the June quarter. There could be something left after the March quarter, and who knows, they may not have been able to pay all the rent in the December quarter. So there could be quite a bit of rent mounting up. And of course, the other point we've all got to bear in mind is that it's a three-way relationship. There's the lender, who almost certainly many of the properties will have been funded by a lender. So the landlord has to make decisions with a lender on its back. And the big thing that the borrower's always got to face facts is the loan to value covenant. So they borrow 60% of the value of the property. Well, of course, with COVID, the value of the property has now gone down. Their lending is higher than the loan to value covenant. They're in breach of covenant, which then means the lender can demand that they pay the balance back to bring that covenant back in. So that's a worry for them. And the other thing, which I don't know whether it's going on very much, is strictly lenders should be consulted if there are any variations to the lease. So lease extensions, rent reductions, that sort of stuff, which should be keeping lenders pretty busy. So it is time for fairness and honesty in the landlord and tenant relationship, in our opinion. There is a new retailers code being drafted at the moment, and as we all know with these sorts of things, they then get spread out across not just retailers but different other sectors within the property industry. As I said, tenants, I think, have to be honest. I think the landlord is entitled to know what's going on, and I think some tenants have used it as a way of trying to get rent reductions rather than taking some pain themselves. I might throw in the professional services sector maybe in that sort of category, possibly. Will highlighted the 2-metre rule, and I do feel that until this social distancing rule is removed, and which there's a rumour that it will be, which is great news, until it's removed completely and safely, business will not be what it was, particularly in the retail, leisure and hospitality sectors. I think it's a fallacy to think that tenants have got a lot of money sloshing around. I think they've been helped, undoubtedly, but I think we're moving away from that. You know, furlough's coming to an end at the end of October. It's being tapered down from the end of August, and probably earlier with some of the contributions to pensions, etc. Grant money's probably been spent. The 10K rate of value under 15,000, 25,000 grant. The C-bills, borrowing, the interest-free periods, we're well into those interest-free periods now. So I don't think it's all good news for tenants in terms of cash that's sloshing around. So I think we've all got to face facts that life is going to be difficult for another 12 months. And I really do think that rent concessions for that length of time are not unreasonable in terms of demand. I think sector and business analysis is important. And I do personally think that service charge and insurance payments should be made, because I think if tenants had those properties, they'd be having to make those payments themselves, albeit that service charge from demands from a landlord must be sensible. So I think it does remain, it's all about cash, but it also is now all about trust between that landlord and tenant relationship. So thank you for listening to my little bit of a sermon on where I think things should be. I'm going to hand back to Phil, who's going to deal with break clauses. But what we would like to do is just do 2 further surveys or polls. So I think they're going to appear on your screen shortly. We'll give you 30 seconds to answer each one of those. And then I will hand back to Phil, who will deal with break clauses and how they link in with rent concession notices.
John, while people are voting, we had a poll earlier. Are we going to, do you want to sort of, I think it may have flashed on screen, but are we going to sort of see the results of the earlier poll? Yeah.
Do you want to run through that, Phil?
Sure. We'll wait till this is finished, and then I think what we'll do, we can run through the results of.
Brilliant. Yeah. Good.
These as well. Okay.
Very good.
So I think you can all see the poll. Tom, who's the man behind the controls here. Can we go to the results of the first poll, if that's possible?
We can't, but the results for the first poll was 41% said yes and 59% said no.
So interesting. It's almost 50-50 people that are using. We said professional advice, of course. That doesn't mean lawyers. It could be, of course, other industry professionals. And then you can see the results of this poll. So, what period of rent concessions he's seeing at the moment? Majority, as we expect, 3 months. Some 6 months. Small amount, 12 months, and then other. And what type of rent concessions are we seeing? Complete rent suspensions. That's interesting, actually. Deferment, the majority, and that tells what I've seen, and then other. So in terms of what I've seen, and the terminology, by the way, I've dealt with some disputes because the parties are not actually sure what they've signed up to because they haven't used solicitors, and I'll come to that shortly. But what we say is a full rent suspension or rent waiver. For example, that means, they may agree that for the March quarter, that means the tenant's not paying rent for that March quarter ever. That's it. Deferment, what do we mean by that? That means that obviously the rent is not paid now, but will be paid at a later date. And it's very important that any agreement is properly documented, ideally use solicitors, say that. But it's just certainty. Look, people watch Judge Rinder, and a lot of the disputes are because there's no certainty. Things aren't written down, and the parties are at cross purposes. Get it properly documented. So rent deferment, it may be that the March quarter, the June quarter is deferred and then paid in addition to the normal rent, but without interest over a later period, or maybe over the rest of the term of the lease. I've also seen agreements to extend the term of the lease, which technically is a re-grant of a new lease, and say, well, look, we'll give you 6 months rent free now, but you agree to have another 6 months added on, or 12, whatever the period is. So that's other things that I've seen. I'll take this down now and crack on with where we are now. So I'll just briefly touch on breaks. I'm not going to go through the law of break notice. What is a break in a lease? It's an option. Can be for landlord or the tenant, but more commonly, and we'll look at it in this context, for the tenant to bring the lease to an end earlier than the end of the contractual term. They usually come with conditions that the tenant must adhere to for the break to be valid, for it to be validly exercised and effective. And the case law shows that if the break is not adhered to the letter of the lease, then it will be invalid. The court will not step in and save the tenant. There's no what the landlord ought reasonably to have known. If the break notice should have been served on polka dot wallpaper, not similar to John's, and it's served on white paper, it's invalid. It must be on colourful polka dot wallpaper. A typical break clause may be like this one that we've got on screen now. So the tenant may end the lease on the 24th of December by giving not less than 6 months notice in writing its intention to do so, and the lease will then end on the 24th of December. Let's assume that the term might end in 2023, so it's getting it 3 years early, subject to the tenant complying with the following conditions. These are typical conditions: paying the annual rent due under the lease before the break date, and yielding the premises up with VP. So why is this relevant now? Well, we've got these rent concessions that are being dealt with, and I've seen some very there's probably been misses that we haven't seen, but I've seen some near misses where the parties, my clients, in this case, recently acting for a tenant who'd agreed a rent concession, but hadn't thought about how that might affect the break clause, which is thinking of triggering, and of course, lots of tenants are thinking of triggering break clauses, or threatening to trigger break clauses with a view to negotiating better terms. Well, a lot of that at the moment from retail clients, thinking, well, you know, we've got a break clause, landlord, we're thinking of doing this, you know, we've instructed our lawyers, we've prepared the paper, but we want you to, we may think about not doing it, but we want better terms, we want more flexibility, we want a COVID clause inserting in the lease. So a rent concession or some other concession, often documented by side letter, could be a deed of variation, but more commonly a side letter. They're quicker, they're cheaper, but should still be done by solicitors to make sure they're legally binding. If the break clause hasn't been considered in the agreement to change the rent payments, it could give rise to uncertainty as to whether or not the tenants validly exercise the break clause. So, for example, there could be an agreement that the tenant for the March and June quarter pays 50% of the rent. But let's just go back to the previous slide. The rent's only valid if the annual rent falling due under the lease has been paid on or before the break date. Does that mean the concessionary amount of rent or the full amount of rent? Well, remember, they're strictly complied with. So the chances are, I would hazard a guess, that it should mean the full rent, unless your rent concession agreement, your side letter, or deed of variation, specifically says something along the lines of, you know, for the avoidance of doubt, the break is still exercisable in light of this rent concession, and it should be construed as paying the lower amount of rent, or the conceded rent, or the deferred rent, or whatever the agreement is. As I say, I've caught one for a tenant who hadn't paid its attention to that. I suspect we'll see some disputes coming through in due course. Vacant possession, it's less common now to see it in modern leases because it's a very onerous hurdle as a condition to a break. Often it says free from subsisting subleases, etc., but it's still there. What happens if the tenant can't give vacant possession because of the current restrictions in place? Well, it's less of an issue now because, as we know, the government has relaxed the restrictions on people, so it's not much of an excuse to say I can't go to the premises, socially distance, employ contractors who take into account precautions to remove demountable partitioning. People might remember the NHS Riverside case where demountable partitioning was held not to give VP and invalidated the break. Essentially, if the landlord can reasonably reoccupy or re-let the premises, then if there's a few boxes in there, that may not necessarily prevent VP from vacant possession from being given. But I would say, as all lawyers worth their salt would say, it should be free from all tenants, chattels, removable partitions, and effects. So if I was acting for a landlord on this slide, I'd say no vacant possession hasn't been given, and push it pretty hard. May not go all the way to court because it might not be commercial to do that, but push it pretty hard. We've had some questions in advance. I encourage people, if they've got any questions at all, to put them through the Q&A button, or even the chat function if you prefer, which my colleagues will no doubt pick up upon. I invite obviously John, Will to come in at any point, but these are the questions which we've had when sending out the invite to this. So firstly, has the government announced a moratorium preventing landlords from using statute while winding up petitions before the 30th of June? Has it become law and is it extended? Well, so as I said earlier, it's not yet law. It is going to come into law. It's got its final reading shortly in the House of Lords, but we already know that there's been a case law. John mentioned the Travelodge case even before the bill was published, but now there's the new case that came out recently, RIA Company injunction to restrain a presentation of a petition, and the judge said that in light of this bill that will become law, I'm not prepared to allow the winding up petition to be presented. Is it going to be extended? Well, it's already in the bill that when this act comes into force, there'll be another month added on to the moratorium period. Second question, is the law suspending landlords from instigating forfeiture due to rent arrears before the 30th of June being extended? At the moment, no, but we think it's likely, don't we? and remember, this is forfeiture rent arrears. I did say before, if you've got a tenant that's in breach of its lease because it's parted with possession, for example, or using its premises for an illicit or immoral purpose, serve your Section 146 notice and give them a reasonable period to remedy. And if they don't, there's nothing to prevent you from forfeiting the lease. It's nothing to do with COVID, nothing to do with rent arrears. Landlords are increasingly looking for other reasons to see if they can serve a Section 146 notice as a prelude to forfeiture. Third question, landlords seem to still be able to use the county court procedures for recovery of debt related to rent arrears. Are the courts actually dealing with these? Or have the courts put them on hold? No, as I said, the courts, some courts are slower, but they're adapting more quickly now. The technology has improved rapidly as it's had to across the sector. Just me being able to work from home is nothing short of a miracle. There's hearings online. I've got a hearing tomorrow and another one next week, and I've got Zoom conferences with council, and the courts are adapting, but some courts are deciding that they're going to give priority to other things. So in fact, there is a published list of applications and matters that the court will give priority to over others, and I won't go through them, but debt claims are not at the top of the list, but it's things that infringe on really an individual's liberty, which are being dealt with first and foremost. Can't see any other questions. I don't know if you guys.
We just got one through, Phil, which quite an interesting one, which is I'll pick it up. For break clause, what happens with air conditioning units if they are not removed from the property? Has the tenant given vacant possession? This will be where it's not documented in the lease or licensed to alterations. I mean, my view is if there were canister air conditioning units stuck up on the ceiling, vacant possession is still given, although I think because it is unclear, there would be inevitably an argument with the landlord, and it would be a question of how far that would run. The problem with all of these things and with litigation is it is not clear. But I would say vacant possession has been given if you're talking about a canister on the top or even those air conditioning units on the roof. That would be my answer to that. However, I do think there would be a battle on it because it isn't clear, and that's the problem with that.
Yes, that's absolutely right. And when we need to look at the type of air conditioning unit without getting too technical and boring, if the VP requirement is vacant possession of all the tenants' chattels, for example, but the AC units have become part and parcel of the building itself, of the demise itself, because the way they've been fixed, then the tenant might say, well, okay, it's we're in breach of covenant, but not in breach necessarily of the precondition of the exercise of the break to give vacant possession. So it might give the landlord a right to damages, but not an argument to say that the VP precondition of the break has not been met. But as John said, if you're the tenant in that scenario, you're going to be in a bit of a sticky position. If the break date hasn't yet come to pass, if one was to advise the tenant, I'd certainly say you want to look now at making a retrospective application for consent to the landlord in relation to those AC units, in order to regularise the matter well before ideally the break date comes, because you've got time to sort things out, of course, or even just get rid of them before the break date. But if the break date's already come and gone, or you're very close to it, the tenant, you might struggle. But as a landlord, you'll be rubbing your hands potentially with glee, because you keep the tenant there, or at least on the hook. But ultimately, as John said, everything boils down to two things. First of all, the relationship between the parties, and secondly, it's cash. It's money. Landlords can be as aggressive as they want to be, but you can't get blood out of a stone, as they say. So,
yeah.
Although I'm getting there as a lawyer. I'm getting there.
Phil, Phil and Will, we've got another question come in. We've got about sort of five minutes left of the webinar. if we just pick up on this one, what kind of safeguards do you put in place to ensure tenants accurately report their turnover for the calculation of rent? And that's a question. So I'll go first on that. It is words in a lease, and there'll be very detailed schedule in the turnover provisions about how one has the ability to go and inspect the records. And there'll be obviously a compensation claim for breach of covenant if they haven't reported correctly. But it is very difficult to monitor that because it is a contractual claim, and it's working out how you can get it. I mean, presumably, if they do breach and don't report accurately, there is a right for forfeiture of the lease as well, which once again, probably the landlord doesn't really want the right to forfeit. They want them in occupation. Those are my initial thoughts on that. I don't know anybody else wants to throw anything else in.
No, I think not a lot of people know this, John, but you've got special powers. We don't call him Mr. John Flathers for nothing. So I think what we'll do now is get John first of all to tell us what this Saturday's lottery numbers are going to be, and also to predict what the future might look like.
Okay.
Lottery numbers first.
Yeah. Were we going to have one final poll before we finished? I think there was one we were going to finish off. Can Tom do that quickly for 30 seconds?
So our landlords and tenants acting responsibly.
There you are. That's a 60.
Depends who you are, who the attendee is, I guess, whether you're a landlord or tenant. Because if you yes, if you do. Anyway.
Okay. Lovely. All right. Just finishing off, really. Where we see that? Oh gosh, interesting. Yeah. Yes, that's good. No, 30%. Starting to. That's good. Look at that. Look at that split. Well, at least we're moving in the right direction, isn't it? I think that looks the things. Okay, just finish off very quickly. What sort of things do we expect to see in the future? My views on that are COVID is a one-off event. I'm going to kick off by saying I fear that we might revert back to type, but sort of the things that we're going to see are turnover rents. There's been suggestions of upwards and downwards rent review being brought in on the December 2021 time to rebalance, and I think that would be a very fair thing. Who's going to go for that, I don't know, but that would rebalance where things are, businesses having picked up again. Longer rent freeze as we get back to normal. Frustration, COVID type clauses will be always touted. Whether they're going to be acceptable to landlords, I don't know. And finish off quickly on that. Frustration does not affect a lease. It's one thing we didn't cover in this seminar, but to argue that the lease is frustrated, the law has never moved that way for donkey's years, and I cannot see it changing again. So enough probably said on that. Maybe shorter leases. One suggestion has been made is that we gear the rent payment dates more to productive periods for certain tenants. For example, the Black Friday period when they're flushed with income. Maybe you gear the big payment dates for that sort of period. But as I say, ultimately my view is I think some normality will revert back, I hate to say. Any other thoughts from Will or Phil?
I don't think I could disagree too much with you, John. I think it just seems to be sort of a moving feast at the moment, and we will end up where we end up. But yeah, I think at the moment it's positive between landlords and tenants, so that's certainly what we're finding, and we just hope that continues.
Phil, anything to say?
No, all I would say is my Amazon man has just rung the doorbell, so I do apologise for the interruption.
Well, on that note, it's a great time to sort of sign off, isn't it?
Thank you for everyone. Yes.
Yeah, thank you for all for attending. Thank you very much.